Okay, welcome back to part 2 of chapter 9. So let's go ahead and just jump right in. So we left off, we were getting ready to kind of go into judicial decision making. So in a ideal world, judges would base their decisions on the law and not let any personal biases and or preferences kind of seep in. And unfortunately, the law is but one factor that appears to influence judges' decisions. Researchers have long found that judges' decisions are influenced by factors such as their ideology, their attitudes, even some of their opinions. Okay, demographic characteristics could also influence their decisions. And then even, re-election. So, some of the research is focused on some high-level judges that, has found that those that are vying for higher positions or re-election, etc., there might be some influence as far as their judicial decision making. So, important for us to understand. When it comes to attitudes, ideology, and opinions, judges' decisions are influenced by the attitudes, ideology that they bring to the bench, right? Each person. And this is especially true of the U.S. Supreme Court justices. The authors of one important study found that Supreme Court justices' ideology and beliefs were almost perfectly kind of correlated with their decisions. And judges' attitudes and ideology also appear to be shaped by their public opinion, etc. We talk about demographics really quick. Judges' sex and race may influence their decisions as well. So there's all things, a bunch of different things that can influence somebody's decision. And then again, talking about re-election, if a judge is facing re-election, to what extent should this factor into their decision making? Well, could it? It is possible, I guess. So these are all items of concern or things for us to think about. Well, what about the prosecutor then? So the prosecutor is one of two adversaries who face each other every day in the criminal justice process. And the prosecutor, who represents the state's interest and serves as the people's attorney, and the defense attorney is the one who represents the accused. Prosecutors, however, they're called the gatekeepers to the judicial system, using discretion, of course, on who to charge. So they do have that authority on who to charge and actually what to charge. So again, that prosecutor is one of two, because remember, in the court system, it's an adversarial process, right? You have the prosecutor against the defense, and each, the prosecutor and the defense, they bring out facts. Remember, each person is going to bring out different facts. And then the trier of facts, which would be the jury, right? They're going to make the decision. So the prosecutor, again, represents the state's interests and serves as what we call the people's attorney, and the defense attorney represents the accused, and this is part of this adversarial process. Now, the prosecutor is an appointed or an elected member of the practicing bar who is responsible for bringing the state's case against the accused. Okay, so there's a lot of duties for everybody in this particular system. Now, depending on the level of government and the jurisdiction in which the prosecutor functions, he or she may be known as, and here's some names. You know how they have different court names? Well, the same thing with a prosecutor. Could be the district attorney, county attorney, state's attorney, or even a U.S. attorney. But whatever the title, the prosecutor is an appointed or elected member of the practicing bar who is responsible, again, for bringing the state's case against the accused individual. And although the prosecutor's primary duty is to enforce criminal laws, his or her fundamental duty is to seek justice as well as convict those who are guilty. So truth seeking, right? And if the prosecutor discovers facts suggesting that the accused is innocent, then of course he or she must disclose this information. And there's a couple of cases that we'll talk about later on in lectures on why they need to do that. Okay, so what then, we talked about the different types of prosecutors, etc., but what do they really do? I mean, there's so much there, right? What do the prosecutors what are some of their duties? Well, they investigate possible violations of law. They cooperate with police in investigating a crime, determine what the charge will be, interview witnesses in criminal cases, review applications for arrest warrants and search warrants. They subpoena witnesses. They represent the government in pretrial hearings and in motion procedures. They enter into plea bargaining negotiations. They try criminal cases. They recommend sentencing. And they represent the government in appeals. Now, those are just some of the prosecutorial duties. And if you look on page 354 and 355 in your textbook, there's kind of a laundry list of prosecutorial duties along with careers that are relative to becoming a prosecutor or an attorney, if that's something that interests you. So what are the different types? So now we know what the prosecutor is and does. So what are some different types or names, if you will? So here's some types. So in the federal system, the United States Attorney serves as the nation's principal federal litigator appointed by the president. And the Attorney General, this is the chief legal officer and prosecutor of each state and the United States. And then finally, you have this name you probably recognize more than all of them, would be the district attorney. And this is the county prosecutor who is charged with bringing offenders to justice and enforcing the criminal laws of each particular state. So there's a couple of different types by definition, if you will. And if you look here, here's kind of a schematic, if you will, of a county district attorney's office and how the different subdivisions fall underneath them. Okay, kind of continuing with the prosecutor. One of the most important aspects of their functions, okay, of the prosecutor's many functions involves the relationship between the prosecutor and law enforcement. And that's really, important when it comes to, processing everyday offenses and major crimes. The prosecutor often relies on law enforcement officers to provide and initiate the formal complaint, right? With more serious offenses, such as some felonies, the prosecutor's office may become directly involved in the criminal investigation as well. Some district attorneys' offices carry out special investigations of things like organized crime, corruption of public officials, corporate crime, white-collar crime, as well as some vice and drug offenses. So, police and prosecution or prosecutorial relationships vary from one jurisdiction to another, and they often depend on whether the police agency is supplying the charge or the district attorney is investigating the matter. But in either case, the prosecutor is required to maintain regular contact with the police department to develop the criminal prosecution properly. And that's important. And some of the areas in which police officers and the prosecutors work together would be the police investigation report. And this is, this report is one of the most important documents in the prosecutor's file because it's basically a statement, right, by law enforcement that details the crime, including all the evidence needed to support every element of that offense. And it really is a critical first step in developing the government's case against the suspect. So really important that we kind of understand that. And here's the three. We talk about the police investigative report, legal advice, and training of personnel. On the right, you see kind of a basic police report form. But again, this is the statement. This is the starting of everything, and it has all of the information in it that the prosecutor is going to need. And there might even need some follow-up investigation. Okay. So we'll kind of, go a little bit further. Providing legal advice. Often the prosecutor advises the police officer about the legal issues given in a case. And the prosecutor may also assist the officer by basically limiting unnecessary court appearances, informing the officer of the dispo of the case, and even preparing the officer for pretrial appearances. And they also help with training, as we talked about. In many jurisdictions, prosecutors help train police officers, especially in things like getting search warrants, how to write a search warrant, what is necessary, making legal arrests, interrogating persons in custody, and even doing lineups. So, again, those three things that are super important, where law enforcement works hand in hand with the prosecutor, would be the initial police investigation and the report, sometimes the legal advice and case prep, etc., and then training of personnel. Okay. All right. So now we're going to talk a little bit about, as we talk about the prosecutor, we're going to slip something in called the grand jury. Now, this is a group of citizens chosen to hear charges against persons accused of a crime and to determine whether there's sufficient evidence to bring a person to trial. And at the adoption of the Fifth Amendment, every state required an indictment for felonies before a grand jury, and some states still do. So early on, it was basically, in order to get a case prosecuted, etc., you had to convene a grand jury, and they would basically decide. And the way they do that is through what they call a true bill or a no bill. And if the grand jury decides the allegations are true, it's not the trial. It's basically a kind of a closed secret hearing almost, where they hear evidence and they decide if there's enough to go ahead and go to trial, to indict the person. And if they believe it's true, it's a true bill. If they believe it's not, or there's not enough evidence, then it's a no bill. But now later on, thank goodness, there's a case called Hurtado versus California. Hurtado versus California. And here the U.S. Supreme Court addressed whether states are required to provide a grand jury indictment. And basically the answer was no. So now there's two ways that the case can go forward: by indictment of a grand jury, or by what we call a preliminary hearing. And both of these are instances where evidence is looked at, basic statements are taken, and in the grand jury, it would be the case of the actual people in the grand jury that decide if there's enough to go forward. And in the case of a preliminary hearing, it would be the judge. So two different ways. Hurtado versus California, a really important case. And here actually is a copy of a real, if you will, indictment. And there's pages missing, but I want to show you the front page. And this was the indictment of Michael Vick, the football player, for the animal abuse cases. And you can see the indictment, and it lists all the information. And at the very end, it says true bill, which means that they found that there was enough evidence to issue the indictment to move forward with a trial. It's not a trial. It's a hearing to determine if there's enough evidence, just like the preliminary hearing. But the preliminary hearing is by a judge. The indictment is through the grand jury. So hopefully that kind of makes sense. All right, so let's talk a little bit more now as it relates to prosecutorial discretion. So, even in felony cases, the prosecutor ordinarily exercises considerable discretion in deciding whether to charge a person with a crime. So this prosecutorial discretion is the prosecutor's authority to decide whether to bring a case to trial or to dismiss it outright. And the prosecutor has very broad discretion. And it's subject to a few, limitations. Okay. And we'll talk about that. So, after a police investigation, the prosecutor may be asked to review the sufficiency of the evidence to determine whether a criminal complaint should be filed. And in some jurisdictions, this may involve presenting evidence, as I talked about before, which was the preliminary hearing, right? Or it could be a grand jury. So we've talked about both of these things, but here's some factors that are linked to prosecutorial decision making. Okay. First would be system factors. Next would be case factors. Next would be disposition factors. And then finally, it could be political factors. All right. And these are all, what we call these are factors that are linked to prosecutorial decision making. So give you a little bit more broad here. We'll kind of open it up. System factors could be the cost of the trial, the court backlog, serious crimes over less serious crimes. Case factors could be the strength of evidence, the victim or the offender's background, the injury of the victim, the amount of cooperation by the suspect, or whether they used a weapon. So again, these are all factors linked to prosecutorial decision making. Some of the dispositional factors could be maybe a preference for diversion or some type of treatment program. So instead of filing the case, maybe a first-time drug offense, they're going to give the person drug diversion. And then there could be some political factors. Pressure, public outrage, media scrutiny, and we know the media can really cause issues and pressure as well, right? And then lobbying or political efforts. So all of these are factors that are basically linked to, the discretion and the decision making that prosecutors have. So what then would be some reasons that maybe your case would not be filed? Okay, so here are some common reasons for what we call a rejection or dismissal of a criminal case. It could be insufficient evidence. So you didn't have enough evidence to get your case filed. Could be problems with witnesses. It could be in the interest of justice, meaning that, it really doesn't amount to a lot and the person may have already paid a penalty or been injured or something else. So in the interest of justice, we're going to go ahead and dismiss this case. It could be a problem with due process. It could be they pled on another case. So now, they're going to go ahead and just dismiss this one. We talked about pretrial diversion. So it could be instead of moving forward, we're going to give the person diversion, meaning we're going to send them to treatment or whatever, and then we're going to kind of divert the case and not file it. Or it could be a referral for a different type of prosecution. So all of these different things can basically result in a rejection or dismissal. And then sometimes, just to let you know, the case doesn't get filed because maybe we talked about insufficient evidence. Maybe you just don't quite have enough, and the district attorney will send it back to you wanting maybe another interview, or go look at this evidence over here and tell me what you find, and maybe just adding a little bit more to the case, right? So it doesn't mean that your case is going to be rejected forever. It means that maybe they just want you to do a little bit more follow-up. Okay, so now we're going to move on to the defense attorney. Now, the defense attorney is the counterpart, right, of the prosecuting attorney in the criminal justice process. And the accused, we know, has the right to counsel, and if a defendant can't afford an attorney, the state must provide one. And I included a copy of my Miranda card, and this is what you must read to an individual as a law enforcement officer. If two things are present, custody and interrogation, Both of those must be present for you to have to, if you will, advise someone of their Miranda rights. Okay. But you can see the rights there, so I'm not going to read them to you. But typically we have them on a card, um, and that's what we're supposed to read to an individual. Now, like the defense attorney, or the defense attorney, like the prosecutor, that person is also an officer of the court. And as an attorney, the defense attorney is obligated to uphold the integrity of the court or the legal profession and to observe the requirements of what we call the model rules of professional conduct in the defense of their client. And sometimes it's kind of a fine line where attorneys get a little emotional or overzealous, and then the judge is the one that will keep them in check, etc. But they are to maintain, their composure, etc., while putting on a zealous defense, but not overzealous. Okay, so that's important for us to understand as well. So, the legal defense attorney, this is legal counsel for the defendant in a criminal case, representing the accused person from arrest to final appeal. And, sometimes these legal defense attorneys experience a lot of conflicts because some of the duties, and we're going to kind of take a look at them in a minute, they kind of, I wouldn't say get in the way, but you're going to see some conflicts, okay? So here's some of the defense attorney's duties, if you will. Investigating the incident, interviewing the client, police and witnesses, discussing the matter with the prosecutor, representing the defendant. Of course, they enter into plea negotiations, preparing their case for trial, filing and arguing legal motions with the court, representing the defendant at trial, providing assistance at sentencing, and then determining the appropriate basis for an appeal if there is one. And on page 364 at the bottom, there's kind of a little laundry list of defense attorney duties, kind of like we looked at with prosecutor. So again, as an officer of the court, along with the judge, prosecutors, and other trial participants, the defense attorney seeks to uncover the facts and the elements of the criminal act. And attorneys are also required to keep their client statements confidential. That is to honor what they call the attorney-client privilege. And within that attorney-client privilege, there are many ethical dilemmas that kind of fall in there. And if you've taken the Ethics in Criminal Justice course, which is AJ102, which is my pitch, it's a great class, and we talk a lot about ethics of attorneys, both prosecutors and defense attorneys, okay? But, again, just understanding that, there's kind of a dual capacity here as both defense advocate and officer of the court. The attorney, that defense attorney, is often confronted with some conflicting obligations to their client and profession, right? So we have to kind of understand that there are going to be some things there. And other equally important issues kind of confound a lawyer's ethical responsibilities. Lawyers are required to keep their client statements confidential. We talked about it. That is to honor the attorney-client privilege. I mean, suppose the client confides in you that he's planning to commit a crime. What are the defense attorney's ethical responsibilities? The lawyer would have to counsel the client to obey the law. And if the lawyer assisted the client, in engaging in illegal behavior, the lawyer would be subject to, charges of unprofessional conduct and criminal liability. If the lawyer believed that the danger was imminent, he would have to alert the police. So you can see there's some conflicts in here, right? I want to make sure that I don't get to those yet. Okay. What should the attorney do when their client reveals that they committed a murder, let's say, and that an innocent person has been convicted of the crime and is going to be executed? Should the attorney do the moral thing and reveal the information before a terrible miscarriage of justice, or should the attorney do the professional thing and maintain the client's confidence. So there's a dilemma in general. So you know, there's no obligation on the defense attorney's part to disclose client confessions or guilt in the absence of a confession. However, okay, defense attorneys are prohibited from knowingly allowing their clients to take the stand and offer false, or what we call perjured, testimony. And because the defense attorney and the prosecutor have different roles, their ethical dilemmas may also differ. The defense attorney must maintain confidentiality and advise their client of the constitutional requirements of counsel, the privilege against self-incrimination, and the right to trial. And the prosecutor represents the public and is not required to abide by these same restrictions in the same way. Okay, so so keep in mind. So it's very complex, right? When you kind of think about it. Okay, so just kind of talking about it a little bit more, and then we're going to move on. In some cases, the defense attorney may be justified in withholding some evidence, but again, they have to be careful that they don't cross that line. As a practical matter, ethical rules may differ because the state is bringing the action against the defendant and must prove the case beyond a reasonable doubt. And this is also why a defendant who is found guilty can appeal. Whereas, a prosecutor must live with an acquittal. And it's why, defense lawyers generally have more latitude in performing their duties on behalf of their clients. But neither side really should encourage any type of unethical practice. All right, so quickly, we're going to talk a little bit about defending the accused. There's a couple of important cases to go over. So the Sixth Amendment's right to counsel and the Fifth Amendment and 14th Amendment, amendment's guarantee of due process have been judicially interpreted together to require counsel in all types of criminal proceedings. And one of the real big cases that's super important would be the Miranda versus Arizona case. And I'll let you research that case on their own, but basically this individual was involved in a rape, admitted to it, actually wrote out a confession, and because Mr. Miranda was not advised of his Miranda rights, meaning the fact that he didn't have to say anything, he had the right to remain silent, and he had the right to an attorney, etc., there were obviously some issues. In the case is Miranda versus Arizona, 1996. And then another real critical issue in the justice system has been whether an individual who can't afford the right to counsel, can an accused person who is poor and cannot afford an attorney have a fair trial without the assistance of counsel? The answer here is no. The case is Gideon versus Wainwright. And yeah, it's kind of an older case, but it's really important that we understand that, here this case took a very good look at, the court unanimously held that in criminal cases, states are required under the Sixth Amendment of the Constitution to provide an attorney to those who are unable to afford their own attorneys. Okay, so a landmark precedent case, as we've talked about before, and the same with the Miranda versus Arizona case. So, this case as well extended the right to counsel, which had been found under the Fifth and Sixth Amendments, to impose requirements on federal government by imposing those requirements upon the state. So, not only is it a federal issue, but it's a state issue as well. Okay, so we're going to talk a little bit now about, we're talking about defending the accused. But when does the right to counsel actually start? So the right to counsel, and we're going to look at a couple of definitions as we go along, begins at the earliest stages of the justice system. And of course, a defendant who lacks the funds, we just talked about this, to hire a private attorney is entitled to counsel free of charge. And this person is basically, the term is indigent defendant or indigent. Okay, however you like to say it. And typically that person would be afforded what we call a public defender. And this is an attorney employed by the government to represent criminal defendants who cannot afford to hire an attorney. Now, the first public defender program in the U.S. opened in about 1913 in Los Angeles, and over the years, primarily as a result of efforts by judicial leaders and bar groups, if you will, the public defender program became the model for the delivery of legal services to those individuals in criminal cases who could not afford an attorney. But so that's the definition of a public defender. Now, in contrast to the public defender system, if you will, would be the assigned counsel system. And this is a private attorney appointed by the court to represent a criminal defendant who cannot afford to pay for an attorney. So you can see there's a little bit of a difference, right? When we talk about the assigned system. So the private attorney is selected from a list of attorneys maintained by the court and is reimbursed by the state for any legal services rendered to that particular client. And assigned counsels are generally used in these rural areas, which really don't have sufficient caseloads to maybe justify a full-time public defender staff, which kind of makes sense, right? And then another system would be the contract system. And the contract system is kind of a relative newcomer in providing legal services to those that can't afford an attorney. It's being used in small percentages of counties around the United States. And in this system, a block grant is basically given to an attorney, the firm that the attorney works for, to handle cases for those that can't afford it. Okay. And in some instances, the attorney is given a set amount of money and required to handle all the cases assigned. And in other jurisdictions, contract lawyers agree to provide those legal representations or legal services for a set number of cases at a fixed fee. And then finally, you have a mixed system. Okay, and this is a system that uses both public defenders and private attorneys. So you can see maybe it is a little more complex, right, than you may have thought of right away. But when we compare them, though, if we compare these public versus private attorneys, is there a difference? Do criminal defendants who hire their own private attorneys do better in court than those who depend on legal representatives provided by the state? And although having private counsel does offer advantages, national surveys indicate that state-appointed attorneys, they do well in court as well. And there's some data that you can look at in your textbook that talks a little bit about, how well they do. Now, private counsel may have a slightly better track record in some areas, but again, court-appointed attorneys do well as well. And then what about conflicts? What are some of the conflicts that have, when we talk about defending the accused? So conflicts have helped erode the formal justice process, which again is based on that adversarial system, right? We talked about it. It's the system of the prosecutor versus the defense and the bringing out of the facts from each case that's presented. So the informal justice system revolves around the common interest of its members to move the case along and settle matters. And then you have to kind of bring into the fact of plea bargains, right? I mean, are these really appropriate things? There is a need for plea bargaining, right? It unclogs the system. It makes the case go quicker. It saves money. But there could also be some individuals that might feel pressure to take a plea. So it's kind of a double-edged sword sometimes. And both prosecutors and defense attorneys find themselves more often working together to get the case done or pled out, as we call it, rather than fighting it out. or wasting each other's time, or even risk losing the case. So these are things, when we talk about conflict in this adversarial process, we know that there's a need for plea bargaining. We can't try every single case that comes through the court system, and not every case needs to be tried, but the adversarial process is that we fight it out. But a lot of times now what we're seeing is people trying to work it out instead of fight it out. Criminal defendants may find that everyone they encounter in the courtroom seems to be saying, plead guilty, take a deal, let's kind of get it over with. And that might even include, unfortunately, sometimes the judge, the prosecutor, and the defense. Now, that doesn't mean there's not a good place again for a plea bargain. But we don't want to just make that the norm, right? Because that's not the adversarial process that we're talking about. Okay, so we covered a lot. We actually did really well on our time frame, so that's really good. So with that being said, that is going to basically wrap up part 2 of our Chapter 9 lecture on court structure and personnel.